have noticed that the issue of Trump being disqualified from appearing on ballots has been gaining more and more attention in the last few weeks. And this all stems from Section 3 of the 14th Amendment to the Constitution, which states that no person who previously swore an oath to support the Constitution but then engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof, can be allowed to hold any federal or state office. Well, it turns out that now, the people who would be responsible for organizing those ballots have begun to speak out. Arizona's Secretary of State Adrian Fontes spoke with NBC about the fact that his office is now figuring out how to handle potential complaints or legal challenges over whether Trump should be allowed on the ballot. He said, quote, "We have to have a final certification for eligible candidates for the primary ballot by December 14th for Arizona's presidential preference election. And because this will ultimately end up in court, we are taking this very seriously. We need to run an election. We need to know who is eligible, and this is of incredible national interest. We aren't taking a position one way or the other. If there are people who want to fight this out, they need to start swinging because I have an election to run." And I don't think Fontes is an outlier here either. New Hampshire Secretary of State David Scanlon, a Republican, is also contending with the same issue as a Republican prepares to bring a 14th Amendment challenge against Trump. According to NBC, Scanlon said he's not seeking to remove any names from the presidential primary ballot, but is trying to figure out what to do about potential challenges that are brewing. And here's Michigan Secretary of State Jocelyn Benson explaining her take while speaking with Nicole Wallace.
Secretary Benson, I know this conversation is in its earliest stages with sort of the legal framework being put out there just this week by Judge Ludig and by Professor Tribe. But what questions would you have if this is indeed what the Constitution would require folks like Mr. Raffensperger and yourself to do?
Well, thanks, Nicole. I think that's the right way to frame it right now. And first and foremost, I want to be clear. I'm going to follow the law. What the law says is what is going to dictate how I hope all of my colleagues proceed in this moment, in particular around thorny issues like this one. Now, in following the law, that means being very careful, making decisions not from a political standpoint, but from a legal standpoint, and asking questions like about due process. Now, typically, a conviction is used to determine the facts and solidify the facts when someone is deemed ineligible, when there are perhaps thorny issues at play. If we're not going to predicate this on a conviction under the law, then what and how do we ensure due process? How do we define insurrection or rebellion? Who makes that determination? And what potential guardrails do we need to have in place so that this is not this precedent that could be created if this legal interpretation is adopted? How can we avoid that being weaponized in the future in this era of false equivalency by officials who want to block candidates from the ballot simply because they disagree with them politically? So this is a really thorny, challenging issue. But and I should emphasize that particularly those of the secretaries in battleground states, I'm going to be talking with Al Schmidt in Pennsylvania, with Cisco Aguilar in Nevada, with Brad Raffensperger, because we know in particular in our states the impact that this decision could have, not just among our voters, but in the nation. And so we're taking this seriously, we're looking at it carefully, and we're weighing all of the thorny issues at play.
So at this point, we're clearly at the stage where evidence is being gathered. And look, let's be fair here. This isn't going to be easy for these secretaries of state. Regardless of how ironclad the Constitution is in its disqualification for someone who engages in or aids in insurrection, which Trump has clearly done, let's not pretend for a second that the backlash won't be swift and severe. That's not an enviable position. But its difficulty does not negate the fact that that's the job. Remember, Trump's incitement of the insurrection was no one's fault but his own. He summoned them to the ellipse. He chose to incite that mob to violence. He told them to march to the Capitol. He told them to pressure Mike Pence into doing something that he had no power to do. So if secretaries of state follow the Constitution and leave him off the ballot, it won't be their fault, it will be his. And keep in mind, they'll be acting on advice from legal scholars, constitutional experts, and prosecutors. Here are just a few people who've made this point.
2024 presidential candidate Asa Hutchinson, who will join me in a bit, he says that Donald Trump might be disqualified from holding office based on the 14th Amendment, which says that U.S. officials who engage in insurrection or rebellion or aid and comfort them cannot hold office again. You were not only an impeachment manager in the January 6th impeachment of Donald Trump, you were a constitutional scholar. So do you agree with Asa Hutchinson on this?
Well, absolutely. And we've been saying all along that Section 3 of the 14th Amendment presents a clear and unequivocal statement that anyone who has sworn an oath of office, and by the way, not just a president, but members of Congress and others who hold federal office, who engage in insurrection or rebellion, having sworn an oath to uphold the Constitution against enemies, foreign and domestic, can never serve again in federal or state office. And this was added after the Civil War as a general constitutional principle, and we have to abide by it. Donald Trump was impeached by the House of Representatives for inciting an insurrection against the Union, and then 57 of 100 senators determined as a constitutional fact that Donald Trump had incited an insurrection. So I think you've got robust bicameral, bipartisan majorities that have already established this as a fact. And I agree with the conservative Federalist Society law professors who are out there saying, as well as Mr. Hutchinson, that Donald Trump is disqualified, just as if he were running and not a born U.S. citizen, or if he were running and he were 24 years old.
But what I want to point out is I'm not even sure he's qualified to be the next president of the United States. And so you can't be asking us to support somebody that's not perhaps even qualified under our Constitution. And I'm referring to the 14th Amendment that a number of legal scholars said that he is disqualified because of his actions on January 6th.
So what would you have officials in your state, any other state, do based on the 14th Amendment? Would you have them just leave Trump off the ballot, off the primary ballot, off the general election ballot?
No, there should be a court declaration, and so there would have to be a separate lawsuit that would be filed in which there would be a finding that the former president engaged in insurrection, and that would disqualify him. That's one avenue. The other way would be that if a specific state made that determination on their own, then that would put the burden on someone else challenging that. Either way, it winds up in court for a specific finding. But I expect those lawsuits to be filed. I expect some states to take that action. But I think it's a serious jeopardy for Donald Trump under our Constitution not being qualified.
Frankly, I got justice goosebumps watching Judge Luttig, who is kind of a lion of a constitutional scholar on the conservative side on the right, and Professor Lawrence Tribe, who is a lion and a constitutional scholar on the left. When I watched those two men come together, both on TV and in a written op-ed, and say that we have both studied this issue, as have other constitutional scholars, and we have concluded that the 14th Amendment, Section 3, is self-authenticating, and Donald Trump is disqualified from being placed on the ballot by Secretaries of State. That, I think, is a powerful constitutional opinion. And the way I'm looking at this now, Brian, is this is the kind of disqualification that, frankly, is no different than being 34 years old or not being a natural-born citizen. These are constitutional disqualifications. And what is the consequence of having a constitutional disqualification? A Secretary of State may not constitutionally put your name on a ballot as a candidate for the presidency. So hold on tight, because this issue is just getting warmed up.
So the question now becomes, how will this happen? What's almost certain here is that a Secretary of State, likely in a blue state, will determine that based on the standards set forth in the Constitution, including the 14th Amendment, Trump is not eligible to run. They'll make the decision not to include his name on the ballot, which will invariably be challenged in the courts. At the same time, a Secretary of State, likely in a red state, will also make the determination that they don't care what the Constitution says, that they want Donald Trump's name on the ballot regardless of the fact that he's no longer eligible based on the 14th Amendment. And so they'll include his name on the ballot, and that too will be challenged in court. And those lawsuits will ultimately hop from state court to federal court, given the fact that electing the president of the United States is a federal issue, and it's all but certain that it'll make its way all the way up to the Supreme Court, which will ultimately have its final say. And what happens at that point is unclear. On one hand, we're talking about a highly politicized institution composed of 2/3 Republicans, including a third of the bench that was quite literally appointed by the guy they'd be ruling against. But on the other hand, if the Supreme Court does find that the constitutional requirements don't apply apply to Donald Trump, then they'd effectively be placing him above the Constitution. And if he wins the presidency, then our system of checks and balances would effectively be destroyed. A president no longer accountable to the Constitution has no need for a Supreme Court. In other words, while this Supreme Court might be right-wing, the issue of allowing Trump to become a dictator is existential for them, for their own judicial body. Meaning, while they might want to be content to ally with him on political issues, they might not be so quick to undermine their own existence and their own power for the guy. So while we're only at the beginning of this process, it is heartening to know that it's on these secretaries' radars. And hopefully they don't sleep on their constitutional obligations to disqualify him from appearing on the ballot, given his conscious decision, I repeat, his conscious decision to engage in and aid an insurrection against our own government. Before you go, I need some help. Please subscribe to the channel and do your part to help grow the progressive media ecosystem. I don't do sponsorships or paid ads, I won't ask for money, but just subscribing to this channel goes a really long way, and it helps get the message out to more people. The subscribe button is right here on the screen. You can also subscribe to my Spanish language channel, which I made to reach those crucial Spanish-speaking voters. That link is on the screen too. And finally, if you want to listen to my audio podcast, you can follow that link as well. Thanks so much for watching.